Hi, I'm Russ Weninger. I'm a wills and estate planning lawyer in Calgary, Alberta, Canada. Today I'm going to discuss what you should consider in picking a guardian for your minor children. In Alberta, a child becomes an adult once reaching the age of 18. In other jurisdictions, the age of majority may be higher or lower. Assuming you live in Alberta, if you have a child under the age of 18, you should have a guardian appointed in your will in case both you and the other parent have died before your child becomes an adult. For people with family in Canada, good candidates for the guardian role are nearby siblings. Siblings are usually close in age and typically have a bond with your children. Parents who are reasonably young and healthy could also be considered, but older parents probably aren't the best choice for guardians. If you are estranged from your siblings and parents, close friends who live nearby may be better choices. For new immigrants to Canada without other extended family members living nearby, there's a bit of a dilemma. If something happened to you, would it be better to have your children move to your home country to live with your siblings or parents, or would it be better for them to remain in Canada and live with friends? This is not an easy question to answer. A lot will depend on the ages of your children, the living conditions in your country of origin, the ability of your children to speak the language spoken in your home country, the citizenship of your children, as well as the preferences of your children. For new immigrants, Canadian friends may in many cases be preferable to siblings or parents living overseas. A guardian should ideally be not too old or too young. Ideally, they should live nearby. They should like your kids and your kids should like them. They should speak the same language as your children. It's not always crucial, but it may be desirable to have a guardian who has similar beliefs and values. Ideally, a guardian will have unfettered access to Canada, either as a citizen or as a permanent resident. The guardianship provisions in your will won't trump family law principles. A biological parent who is not clearly incompetent as a parent is a likely candidate for guardianship. That being said, sometimes a step-parent may take on more of a parenting role than an actual biological parent, and so perhaps a step-parent would make a better guardian in certain circumstances. You can make your preferences known in a will and provide reasons for why you have chosen the person you have chosen, if you believe your choice may be somewhat controversial. Keep in mind that under Alberta law and under the law of other Canadian provinces, judges retain the ability to make decisions on guardianship based on the best interests of the children. In other words, your choice for guardian should be reasonable, or it may not be accepted by a court. If your children are already in school, it's worth considering getting their opinions about possible guardians. Please check out my upcoming video in which I will talk about common ways for people to distribute their estates. If you enjoyed this video, please feel free to like it or share it or subscribe to my channel. If you have a question, please leave it in the comments section and I will do my best to respond. While I don't want to give specific legal advice in the comments section, I will try my best to answer general questions, provided it is understood that my responses to comments should not be taken as legal advice, that social media interactions are not considered lawyer-client interactions, and that your safest course of action is to consult directly with me or another lawyer if you have a legal issue or would like to prepare a will. Thank you.